Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2, Jefferson County, Texas. My name is Judge Terrence L. Holmes, presiding. Today, your case is set for an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and your options. Just hold on a few minutes. Mr. Mendez, would you please put your mic on mute? All right, thank you, sir. And so, as I said earlier, arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have here in this court is a misdemeanor case. Cases are divided into, criminal cases are divided into either a felony case or a misdemeanor case. Now, your felony cases are what we refer to as your most serious cases, and your misdemeanor cases are normally referred to as petty offenses. It does not mean that they are not serious. The difference between the felony and the misdemeanors is the range of punishment. For example, and then you have your felony offenses. They have various categories of felonies, like you may have a capital murder, a first-degree felony, a second-degree felony, a third-degree felony, and a state jail felony. For your misdemeanors, you have a Class A misdemeanor, Class B misdemeanor, and Class C misdemeanor. The difference between the two, as I said earlier, is the range of punishment. For example, if you have a capital murder case on a felony case, your punishment could either be life or death. If you have a first-degree felony case, your range of punishment could be anywhere from 5 years to 99 years to life in the state penitentiary, or fine up to $10,000, and a fine up to $10,000, not or. If you have a second-degree felony, the range of punishment is anywhere from 2 years to 20 years, and a fine up to $10,000. If you have a third-degree felony, the range of punishment is the minimum of 2 years, the maximum is 10 years in the state penitentiary, and a fine up to $10,000. And if you have a state jail felony, the range of punishment is 6 months in the state jail to 2 years in the state jail, a fine up to $10,000. Now, for misdemeanor offenses, in this court, we handle Class A and Class B misdemeanors. We handle Class C misdemeanors only when it is appealed from a municipal court, which is a city court, or a JP court, which is Justice of the Peace. Class C misdemeanors are normally your traffic tickets, speeding, et cetera, like that, not having a seatbelt on. Normally your traffic tickets. Now, the range of punishment for a Class C misdemeanor is fine only. In essence, you only could get a fine. You can't get jail time. Now, for your Class B misdemeanor, which is a step up, that's one of the cases we handled in this court. The range of punishment is anywhere from 0 days to 180 days in the county jail, or anywhere in between, or fine up to $2,000, or anywhere in between from $0 to $2,000. Or you could be given both such fine and confinement. For a Class A misdemeanor, which is higher than the Class B, the range of punishment is anywhere from 0 days to 365 days in the Jefferson County Jail, or anywhere in between, a fine from $0 to $4,000, or anywhere in between, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation that you can get. One type of probation is called adjudicated probation. Normally, we refer to it as regular probation. The other type of probation is referred to as unadjudicated probation. The difference between the two is as follows. With the adjudicated probation, it does result in a conviction on your record. However, There's something that is called judicial clemency. That simply means that the court can has authority to set aside the conviction. However, a couple of things has to happen. First of all, you have to successfully complete the probation. And you cannot have the probation has to expire. There cannot be any more time left on the probation. And you have to successfully be discharged, meaning let off the probation. If those things happen, then any complaint, affidavit, or information has been filed against you can be dismissed. And if it's dismissed, then the court can set aside your conviction, and that simply means you will no longer have a conviction. However, if you get a subsequent conviction later on, another conviction later on, then the court can, if you get another conviction later on, then this case can be revived, resurrected, or brought back up, and it can be used against you. Now, if you try to get a license from CPS, CPS can either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, with the unadjudicated probation, the other type of probation, we normally refer to it as deferred adjudicated probation. With that type of probation, it does not result in a conviction in your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for what is called a non-disclosure. A non-disclosure just simply means that we cannot disclose or to the general public that you were on deferred adjudication for this offense. However, if you violate the terms and conditions of your deferred probation, the state can file a motion to revoke your unadjudicated probation. And if that happens, warrant can be issued for arrest, you could be arrested, and you'll be entitled to a hearing on your case, on the motion to revoke your unadjudicated probation. And if the court finds that the evidence, finds from the evidence that you have revoked your probation, then the court can revoke your probation. And if that happens, you can get a conviction. And obviously, if you get a conviction, your case can't get dismissed and you cannot get a non-disclosure. All right. Now, the forms that's been handed out to you is titled Judge's Explanation of Rights to Defendants Without an Attorney. I'll go over that form with you. And it states, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, it reads, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If you have already been appointed a court-appointed counsel in this case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished initialing one of those lines, then you will sign at the bottom of the document where it says defendant, and you will place today's date on the line that says date. And today's date is May 25th of 2021. You also have a right to have a trial by jury. Where those young ladies are sitting in the jury box, we call that, well, that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors on your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in the case. You also have a right to waive or give up your right to have a trial by jury. And by doing so, your case will come before the court or before the judge, either by a trial, the trial we call it a bench trial if you desire to have one, or by a plea. A plea is if you're pleading guilty or no contest. And so you can do what is called an agreed plea bargain agreement or unagreed. The difference between the two is agreed is you and the state. A plea bargain is an agreement that you have worked out with the state to settle your case. And if you come to an agreement, we call that an agreed plea bargain. If you have not come to an agreement, if you still want your case to come before the court on a plea bargain, we call that an unagreed plea bargain. In essence, y'all have not reached an agreement, but you still want your case to come before the court for the judge to decide what the punishment would be in your case. You also have a right to have you also have a right to have witnesses to come to court. Witnesses sit in that chair right there. We call that the witness stand. They can testify for you or against you. You have a right to ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses on your behalf in your case. You also have a right against self-incrimination, which means you have a right not to testify in your own case, if you so desire. Now, you also have a right to have discovery. Discovery basically means you have a right to see the evidence that the state has, you know, the police reports, witness statements, your statements. You have a right to have access to the discovery. If you have an attorney, your attorney will have access to the discovery, or if you're representing yourself, then they can allow you to have access to the discovery. Now, you also have a right to waive or give up the right to have discovery as well. In essence, you'll be saying that I don't want to have access to the discovery. You have a right to do that as well. Now, as I said earlier, you'll have an opportunity to talk to the prosecutor. For those of you who are represented by an attorney, your attorney will talk to the prosecutor. Or if you are representing yourself, you'll have an opportunity to talk to the prosecutor to see if you can work out a plea bargain agreement. In essence, to see if you can settle your case. If you are able to work out a plea bargain agreement and your case comes before the court does not have to follow that plea bargain agreement. If the court does not follow the plea bargain agreement, you have a right to, or you'll be entitled to, withdraw or take back your plea. In essence, if the judge says that he is not going to follow that plea bargain agreement, then you have a right to take back your plea. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, and what an appeal is, you would like to have a higher court to review your case to see whether or not you have been wrongfully convicted or this court has committed an error by convicting you. If that's the case, then you have to get permission to appeal from the court or from the judge that followed the plea bargain agreement. All right. Now, if the judge gives you permission to appeal your case, the court that it will go to from here will be the Ninth Court of Appeals. The Ninth Court of Appeals is right above us on the 3rd floor. They will review your case and they will decide to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and for this court and order this court to give you a whole new trial. If they deny your appeal, at that point, within 30 days of the denial of your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. The court that you will be appealing to will be the Texas Court of Criminal Appeals. It's the highest criminal court in the state of Texas. It's located in Austin, Texas. And you would have to file what is called a pro se petition for discretionary review. Now, pro se means without a lawyer. You'll be representing yourself. You'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, to see whether or not you've been wrongfully convicted, or to see whether or not this court has committed an error by convicting you. If they grant your petition for discretionary review, they can find you not guilty, or they can order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, Jefferson County has a program for first-time offenders. The program is called PreTrial Diversion. The PreTrial Diversion basically is that if you get into the PreTrial Diversion program, the case will be dismissed, and if you complete it, you can get it expunged from your record. Expunged means it could be wiped off, deleted, or erased from your criminal record. In order to get into the program, first of all, you have to be a first-time offender. Second, you have to have an attorney to assist you with the paperwork that you need to file with the district attorney's office. And third, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. If you are a veteran, Jefferson County District Attorney's Office has a program that is called Veterans Court. It is also part of the PreTrial Diversion program. And this is for veterans of any one of the branches of the United States military, any one of the branches. With that program, because it's a pretrial, it's part of the PreTrial Diversion program, your case could get dismissed and you can get it expunged from your record, okay? And that application process is through the district attorney's office as well. This court, Jefferson County Court at Law Number 2, has a program that I started in March of 2017. So we've been doing it for about 4 years. The program is called the Community Safety Initiative. The Community Safety Initiative, we usually refer to as the CSI Program, Community Safety Initiative. That program, we have partnerships with agencies in our community. We have a partnership with the Spindletop MHMR. And then with Spindletop MHMR, we have a program. If anybody have mental health issues, they can do private interviews. They can do, they have the capacity to do assessments as well as treatment plans, either outpatient or inpatient treatment. Also, Spindletop has a program, a drug and alcohol program. It's called ATAR. It stands for Addiction Treatment and Recovery Program. The program that they have now is for youth, or I can say juveniles, but 21 years old or younger. And if you're older than 21 years old, OZAR, which is a local drug and alcohol counseling program, they can provide the same services. And what they would do is do an assessment, do an interview, not an assessment, but do an interview, a screening, and then they can develop a treatment plan, either outpatient or inpatient as well, where they can help you to get into either outpatient program or inpatient program, depending on what your needs are. And that's for individuals who have problems with alcohol or drug abuse. Now, if you have not obtained your high school diploma, there's a program that can assist you with getting your GED. Now, the program that I'm speaking of is a partnership that we have with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE, and that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, they will assist you with getting employment in the field that you're trained in. And they also have a GED program, which means they can help you to get your high school equivalency diploma. Now, all of those programs that I just spoke of is in our CSI program that we've been, as I stated earlier, we've been doing for about 4 years now. That program, I tell people this all the time. When we instituted the program, we don't have court as usual in county court at law number 2. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the bench, that comes before this court, and we're trying to make a difference in Jefferson County. And the way we're trying to make a difference in Jefferson County is to try to address the issue of recidivism. Recidivism is how when people commit crimes over and over. And so we want to address that by stopping that from happening by producing productive people. And if we're able to produce productive people, for the most part, productive people do not commit crimes. And so when we look at our problem, when we look at some of the things that we are addressing, mental health, drug and alcohol abuse, unemployment, and a lack of education, we tell people this all the time. We don't just arrest the problem, we address the problem. And so we believe if we address the problem, we can make Jefferson County a safer place for all of us to live, work, go to school, go to church, raise our families. And so that's what our CSI program has been about for the past 4 years. And so the good thing about that program is this: it's free. Doesn't cost you anything. It doesn't cost you a dime to put. The only thing you have to do is have a desire or willingness to participate. And it's part of our bonding program. Now, the other thing is this: everyone in here has been arrested and you're out on bond. The other thing is you spent either a minute in jail, an hour, a couple of hours, a couple of days, weeks, or whatever. Any time that you spent in jail, that jail time can be used toward your punishment. So, for example, let's say you and the state has come to an agreement where you are, let's say they're offering you 5 days in jail. They offer you 5 days in jail, you spend 5 days in jail, and then you'll be given what they call credit for time served. In essence, you've already served your 5 days in jail, you won't have to serve any more time in jail. The other thing is, any time that you have spent in jail, it is also credited as $100 per day. So if they offer you a fine and court costs of $500, you spent 5 days in jail, that's $500. So you won't have to pay the $500 fine and court costs, because the time you spent in jail has already paid it off. Therefore, the time will be taxed. The fine and court costs will be taxed and retired. Okay. Now, the programs that I spoke about on the CSI program can also be useful in another way. If you have a fine, if you can't pay it that day, we can put you on a payment plan. But sometimes people are, even if you put them on a payment plan, they won't be able to pay it because of their lack of finances. And so what we can do is we can convert your fine and court costs to community service, right? All of those programs that I just spoke about can be used as community service toward your fine and court costs. So for example, if you are in a job training program, or if you're in a GED program or mental health program or drug program or alcohol program, every hour that you spend in that program, that's 1 hour that goes towards your community service, and that's $12.50 that's also going toward your fine and court costs. So if you spend 8 hours in the program, that's $100 a day. And that's 8 hours toward your community service. So in essence, you're killing 3 birds with one stone. You're paying your fine and court costs, you're doing your community service, and you're also in one of the programs that you may have been assigned to. So, and all of those programs, as I said, are free. And so those are some of the things that, because of the legislature, they have given the court the authority to convert fine and court costs to community service, and then programs like that can be used as well. Okay, so now what we're going to do is we're going to put you into 3 categories. Hopefully everyone has filled out the form. Now, for those of you who has initialed the 5th line, saying you want to represent yourself, I will go over that. You will have to sign the 2nd page, which is the waivers. The waiver of counsel for purposes of entering a guilty plea or proceeding the trial. And it says that I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 25th day of May of 2021, by the county court at law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And so if that's your choice, then you'll sign where it says defendant, and you'll place today's date, May 25th of 2021. And for those of you who are applying for court-appointed counsel, we have some financial questionnaires that you would have to fill out. And once you fill that financial questionnaire out, the proper person will review it and determine whether or not you meet the eligibility requirements of a court-appointed attorney. Now, Ms. Lawless, okay, we're gonna have Ms. Lawless come forward. She's with Spindletop, and she can tell you, give you some good information about the mental health program that they have at Spindletop. Ms. Lawless?
Good morning. As you said, my name is Misty Lawless. I am with Spindletop Center. I am a qualified mental health professional, and my coworker, Ms. Sylvester. And we are in the court, like you kind of explained earlier. We have a program called the Court Liaison Program, because what we do see in mental health is a lot of our clients it's a vicious cycle. They go in and out of jail because they're not getting the help that they need. Now, this may or may not apply to you guys, but we are in the court. We'll be in several courts, but we are here to help. If you have any questions about mental health, drug and alcohol addiction, we can definitely do a quick screening, a quick assessment, or maybe you just need a referral. If you're just having a bad day, and you want to talk to somebody, we're here for that too. We're just here to help and hopefully, like you said, make you make this the last time you come to work. So, if you guys have any questions? Okay, so we're gonna come around and just kind of get a little information. If you have any questions then, or if you want to speak with us, everything we do is confidential. We don't speak to anyone without your permission. So come around, get a little information. If you want to talk to us privately in the back, we'll be here open, as long as you need us, okay? You guys have anything? Okay. Thank
Okay.
you, Judge Holmes.
Okay, thank you, Ms. Lawless. Okay, ladies and gentlemen, excuse me, the court staff is going to come around, is going to go around and pick up your clipboards. You might have to sign some additional documents. They'll look at the documents that you've already signed and filled out, and they'll determine whether or not you need to sign some more documents or not. But just be a little patient with us. This will take a little time. And so at this point, just hold on to your documentation. Somebody's going to come around and they're going to assist you with it. Okay? All right. So we'll be in recess. Let me do this here.